Good afternoon. This is the Supreme Court of the United Kingdom, and we are hearing the appeal in the case of Nora Ziegler and others against the Director of Public Prosecutions. This morning we have heard submissions on behalf of the appellants by Mr. Henry Blaxland QC, and we are now hearing submissions by Mr. John McGuinness QC on behalf of the Director of Public Prosecutions. Mr. McGuinness.
Thank you, my lords, my lady. Before lunch, I had been addressing the court on what the director submitted were the facts either found or implicit in the case stated by the district judge. Before I move on to address the court, as I will do in the same way that Mr. Blaxland did on question 2 first, the application or not of the Re-B test. On the facts, can I just mention one other matter? Which again I submit is implicit from the case as stated by the district judge, that the nature of the appellant's activities can properly be factually analysed as physically impeding activities of which they disapproved, in the same way that the parties in the cases of Hashman and Steele before the Strasbourg court did. And at the very least, they certainly intended physically to impede activities of which they disapproved. What goes with that, on the facts of this case, the director submits, is that they were physically disrupting the lawful activities of others, and therefore affecting the rights of those others, which are not only expressly provided for in section 137 itself, free passage along the highway, but also are referred to in both paragraphs 2 of both articles 10 and 11. And contrary to Mr. Blaxland's submission on this point, the director submits that it would not be inappropriate to describe the appellant's actions as compulsive or coercive. As has been pointed out, this protest occurred before the arms fair had actually commenced. They were not seeking to discuss or to persuade. They were, in fact, intent on a correct factual analysis, on stopping or disrupting the lawful activities of others, and that, as the Strasbourg authorities to which Mr. Blaxland referred the court to, is significant, because while I accept, as indeed the Strasbourg court has accepted, that the appellant's convention rights were engaged, the Strasbourg court in paragraph 97 of Kudrevicius, to which Mr. Blaxland referred the court to, and perhaps the easiest way, rather than ask you to take out Kudrevicius again, is to direct you to the paragraph in the judgment of the High Court, where paragraph 97 of Kudrevicius was cited by the High Court, and it was cited by the High Court in paragraph 53 of its judgments. Forgive me, paragraph 51 on page 106 of the bundle. And the sentence to which I would draw the court's attention to is the last sentence set out there at paragraph 51, citing from the Strasbourg court. This state of affairs, this is the part that Mr. Blaxland read to you, might have implications for an assessment of necessity to be carried out under the second paragraph of Article 11. And in the later paragraphs of Kudrevicius, to which Mr. Blaxland referred the court to, starting at paragraph 170 and going through to paragraph 173, there the Strasbourg court set out, in respect of the facts of that case, what it was referring to in the last sentence of paragraph 97. It was referring to the state of affairs of conduct that is coercive or compulsive. It attempts to force somebody else into doing or not doing something that they don't wish to do or not do. And it's in that context, paragraphs 170 onwards, that the court, the Strasbourg court, referred to the authorities to which Mr. Blaxland referred the court to before lunch, the cases of Steele, the case of Dreeman, the Greenpeace whaling case, the case of Lucas, and can I add one more authority to that? It's the decision of the Commission, the European Commission, in the case of F against the Federal Republic of Germany, and it's referred to, or sorry, not F, it's G, forgive me. You'll find it in the bundle at page 1252. It's a case that is factually similar, not only to the Lucas case, but also to this case. And albeit it is a decision of the Commission, I point out in favour of its persuasive influence that it was cited with approval by the European Court in the case of Lucas, to which Mr. Blaxland took the court before lunch. And it was also cited approvingly by Lord Neuberger, Master of the Rolls, in the case of City of London Corporation and Samid, which the court will find starting at page 711 of the bundle, and at paragraph 39 of that case, Lord Neuberger referred to the the G in the Federal Republic of Germany case approvingly. My lords, my lady, if time permits, I will return with some further submissions on the first question, but in the light of the court's indication, I will move on now to the second question. Perhaps before I leave my factual analysis of the case.
I'm sorry to interrupt you, Mr. McGuinness. Did you say paragraph 39 of Samid?
My lord, I did. Can I just check I've got the right paragraph number? I'll just bring it up, sorry.
Unfortunately, it's not paragraph 39.
No.
I'm very sorry. Then, if my lords will forgive me, my lady, for one moment. Entirely my fault. Paragraph 47, forgive me, page 725 of the bundle.
Thank you very much.
And indeed, the Lord Neuberger set out the relevant extract from G against Germany in the body of paragraph 7 of his judgment. Before I move to my submissions on question 2, the court won't need reminding, but relevant to the factual matrix of this case, this appeal, it's been touched upon already, but it is relevant to the assessment of proportionality, is to remind the court of the Strasbourg authority that proportionality also includes assessing the response of the authorities, not merely, as I was submitting before lunch, the response, for example, of the police at the time of the conduct that's in question, but how it is that in the wider view that the state deals with such conduct, and to remind the court that section 137 carries a maximum penalty at level 4, which is £1,000. It is not imprisonable, and as the court will have seen from the conclusion of the case stated, the case was sent back to the district judge and he imposed a conditional discharge in respect of each of the appellants. Can I now move, please, to the director's submissions on question 1, the test to be applied by the appellate court in assessing reviewing the assessment of proportionality that was made by the fact-finding court or tribunal. In some cases, and this is an example of such a case, a decision in a criminal trial will depend on an assessment of the proportionality of the interference with a defendant's convention rights. It is apparent, the director submits, both from the case stated and indeed from the appellant's submissions before this court, that it isn't argued by the appellants that the existence, the enactment of section 137 was an interference with their rights that was not prescribed by law. It's not argued by the appellants that the interference with their convention rights, which section 137 impinges on, is not in pursuit of a legitimate aim as set out in paragraph 2 of either articles 10 or 11. The appeal by way of case stated and the High Court's approach to the appeal depended on this, in this case, entirely on the district judge's assessment of proportionality. The director submits that as a matter of common sense, an assessment of proportionality in a case such as this is perhaps best described as one of mixed fact and law. Fact, because, as all the authorities make clear, it is so inherently fact specific, but also one of law, because when the tribunal of fact has reached this stage of the analysis, the tribunal of fact is dealing with the balancing task that is placed upon it, the protection of the rights of others under the articles and exemplified by the particular statutory provision in respect of which a defendant is prosecuted, and at this stage, it is accepted the defendant's convention rights which are engaged and have been interfered with. And the director submits that the High Court's description of this exercise that was carried out by the district judge as an evaluative assessment using the language of Lord Neuberger in the Re B case is an apt description. It's more apt than saying that the assessment of proportionality that was carried out by the district judge is a finding of primary fact. It clearly isn't, nor can it properly or more accurately be described as the exercise of a discretion. If, as the director submits, it is a question of mixed fact and law, then it is submitted that it is a question of law for the purposes of section 111 of the Magistrates' Courts Act of 1980. The court will be aware that in general terms, an appeal by way of case stated on a finding of fact is severely circumscribed. And that is consistent, in fact, with the contents of the relevant criminal procedure rule, which is, or was at the time, I think it still has the same number, though the terms may have been amended somewhat. It's Rule 35.3 of the criminal procedure rules, which are set out in the bundle starting at page 580.
Is the text that we see at 581, is that from the 2020 or the 2015 rules?
Well, I hope, my lord, it is from the 2015. But having looked at it, I can see immediately, and for this, the parties must take the blame. It is, in fact, the 2020 version, for which, as I say, the parties, and as this was a provision that the director wanted included, and insofar as I'm at error for not insisting, I think we were aware, both Mr. Blackland and I were aware, that it had been replaced by a 2020 version.
Won't detain you, but if after the hearing parties could confirm whether the wording is identical, that would be sufficient.
My lord, we can do that, certainly.
Thank you.
And one can see from, I'm looking out at page 581, that paragraph 4 of Rule 35.3 sets out what must be in the draft case, and at subparagraph D, if a question is whether there was sufficient evidence on which a court could reasonably reach a finding of fact, that finding of fact must be specified, and the case stated must include a summary of the evidence on which the court reached that finding. And then Rule 35.5 states, except to the extent that paragraph 4D requires, the draft case must not include an account of the evidence received by the court. And this appeal that the director brought by way of case stated is one where there is no challenge, there could be no challenge to the primary findings of fact that the district judge made and which are set out in the case. And as the court also knows, going a step further, as the district judge made plain, in essence, the facts were not in issue. Only one police officer was called. I think each of the appellants gave evidence at their trial, effectively to tell the court why it is that they took the action that they did, and to give evidence about their long-standing beliefs and commitments, all of which, of course, naturally was accepted. So this was not a conventional appeal by way of case stated, in which the director was challenging a finding of fact, either as being one for which there was no evidence or one that was perverse. And as Mr. Blaxland has indicated, the director, represented by me at the High Court, proceeded to put the appeal forward on the conventional basis that is referred to by the High Court. If my lord and my lady turn in the case stated to paragraph 99 at page 116, under the heading, the approach to be taken by the appellate court. The court said the written submissions on behalf of both the appellant and the respondents appear to suggest that it is, whether the assessment of proportionality is a question of fact. That is why it was submitted on behalf of the DPP that the conclusion which the district judge reached was one which no reasonable court could have reached on the undisputed facts before him. So the appeal was launched by the director on a conventional Wednesbury ground. Nevertheless, the court clearly adopted the Re-B test, and adopting the B test, what is required for the appellate court to do, it has to focus on the decision that is being appealed against, in this case, the assessment of proportionality that was made by the district judge. It's clear from the majority in Re-B that the appellate court does not carry out a fresh evaluation. I shall return to that because one of Mr. Blaxland's submissions before lunch was that that is what the High Court did. But what an appellate court has to do is to focus on the decision below and then to determine if that decision was wrong. And wrong means no more or no less than that. This court will be aware that Lord Neuberger's efforts in paragraphs 93 and 94, I believe, of his judgment in Re-B to expand upon that was felt to be unwise by a subsequent decision of this court. But the important feature is that in the Greater Manchester case, which is the case where the court commented on these paragraphs of Lord Neuberger, the court in that case made it plain that its critique or criticism of those paragraphs of the judgment of Lord Neuberger did not in fact affect the validity of the test set out in Re-B. So going back to what it is that the director submits, has to do, it focuses on the decision below. It determines if the decision is wrong. If it is not persuaded that the decision below is wrong, then it dismisses the appeal. If, and moving here to the context of an appeal by way of case stated, if the appellate court concludes that the decision on proportionality made by the district judge was wrong, it then allows the appeal, but touching upon something that was discussed before lunch, the High Court, and therefore it would follow this court, has a very wide discretion as to what it should then do. Starting at page 565 of the bundle is section 28A of the Senior Courts Act of 1981, which we can see from subsection 1 applies in respect of a case stated both on appeal from the Magistrates' Court and on appeal from the Crown Court. Subsection 2 deals with the High Court's power to send the case back for amendment. Subsection 3 sets out the breadth of the High Court's powers once it determines the appeal. It shall hear and determine the question arising on the case and shall reverse, affirm, or amend the determination in respect of which the case has been stated, or remit the matter to the Magistrates' Court or the Crown Court with the opinion of the High Court, and may make such other order in relation to the matter as it thinks fit. So the High Court has a very wide discretion if it concludes that the appeal should be allowed as to what course it can then take. As the court knows, in this case, the High Court did not exercise its power under 3B of Section 28A to remit the matter to the Magistrates' Court, save for the purpose of the magistrate, of the district judge passing sentence, which clearly he hadn't done. Once the conviction was, or once the appeal was allowed and convictions were instated, then the case was remitted for sentence. How does the appellate court decide if the assessment of proportionality is wrong? Well, as I've indicated, it asks the simple question, unembellished, is it wrong? But that, I suppose, doesn't give the appellate court much assistance. Forensically, the appellate's court approach is likely, the director submits, to be one that is not dissimilar to the approach it would take in respect of any question of law. More conventionally, it will examine the reasons that were given below. It will examine those reasons against, because we're here talking about an evaluative judgment, it will examine those reasons by reference to the primary facts that have been found by, in this case, the district judge. It will, entirely consistent with the approach in Re B, give due allowance for the advantages that the trial tribunal, the trial judge, will have had, and that inevitably the appellate court will not have, and the director does not submit to the contrary. The director's submission in respect of this particular case, as set out in our printed case, is that this is a case where one can understand why the High Court felt more able to look critically at the assessment that was made by the district judge set against the primary facts, because this was not a case where there was any, if indeed any at all, factual dispute between the prosecution and the defence. As the district judge made plain in one of the early paragraphs of the case stated, in its paragraph 5 at page 126 of the bundle, in both trials, because of the high level of agreement between the parties, almost all of the prosecution case was reduced to Section 10 admissions and agreed Section 9 statements. In each trial, I heard live evidence from one police officer who gave evidence about what occurred. The magistrate was shown the body-worn video. We can see, as far as the case of Ziegler is concerned, we've looked at it already, the magistrate's findings of fact arising out of the evidence of PC Wright at paragraph 10. He clearly accepted all of that evidence as fact. And going back one paragraph to paragraph 9, he dealt with matters leading up to the arrest, all of which would have been apparent from the video. And then, although he did not deal with this in the section of the agreed facts of the case in Ziegler, if one moves to paragraph 15, I suspect because the district judge determined there being at that stage 2 appeals being launched to do a single case stated, and therefore in paragraph 15, albeit he's now moved on from the Ziegler facts to the Cooper facts, what he has done in paragraph 15, and the director accepts these are findings of fact for the Ziegler appeal, is he set out the undisputed evidence given by all 8 defendants, which of course would have included the 4 appellants, and those findings of fact continued into paragraph 16. However, the context is that this was a case which the fact finder determined in circumstances where there was a high level of agreement. One still gets back, however, applying the Re-B test to the appellate court asking the simple question, was the assessment below wrong? The director accepts that until B, and indeed in a criminal context, until the decision of the High Court in this case, that is the subject of the appeal, the approach in Re-B, which has since been applied, as the court knows, in other circumstances, moving away from childcare proceedings, but certainly in the criminal context, the director accepts, and this is to some extent borne out by the additional authorities to which the court referred the parties yesterday afternoon, is that criminal courts have tended to approach matters such as this by the application of Wednesbury principles.
I think Lady Arden has a question for you, Mr. McGuinness.
Only when convenient. Thank you very much. Could I just ask this question? And I'm sure the answer is blindingly obvious and you'll be able to answer it in a moment and carry on with the submission you're just making. At the start of paragraph 100, the High Court says, "We do not consider that the assessment of proportionality is in truth a question of fact, full stop. It is better described as an evaluative assessment, as described by Lord Neuberger." Now, the point they're making is that it's not pure fact-finding. When you make an evaluative assessment, you have to weigh in the balance certain facts. And that can still be a question of fact. The significance is that you then give weight to the judgment of the decision maker, the fact finder, because he's had all the facts, he or she, and able to strike a balance. And you don't go, you give weight and defer, I think it was said this morning, to the judgment of the fact finder. But at what point does Lord Justice Singh and the High Court deal with the question whether or not the Re-B test is, I'm sorry, not the existence of the Re-B test, but the application of the Re-B test is a question of law? Because we go on into the extract from Lord Neuberger, he doesn't deal with this question, but we have to deal with it because of section 111. So where is it said, I'm sure somebody has said it somewhere, but I'd like to know where, that the actual application of Re-B is a question of law. I have to say I have a little bit of skepticism, and that's why I'm raising the point, because on the face of it, one is simply asking a question of whether the assessment of facts was correct. And that seems also to be what the High Court thought they were doing. In which case, I have some difficulty in seeing you're deciding a question of law, unless you are saying, as I put it to counsel this morning, that there is some normative rule under Article 11, arising from the jurisprudence of under Article 11, which means that there is a defect in law in the decision is reflected in the case stated. That obviously would be a question of law, but when you're dealing with a purely evaluative assessment, where is it made clear that that's a question of law? Or is that a question we're going to have to decide?
Well, the short answer is that one cannot find, and this is certainly I have not found, a simple statement in any paragraph of the judgment of the High Court that provides a direct answer to that question, the court does talk, the High Court does refer to errors of law when, for example, the High Court, starting at paragraph 111 on page 119, refers to the reasoning of the High Court. It does so against the background that, as one can see, if one just goes back to starting at paragraph 106, the High Court went through the individual grounds of appeal that had been put forward on behalf of the director, which in fact had been summarised earlier in the judgment of the High Court, starting at paragraph 35. There's less detail perhaps given starting at paragraph 106 as to what those submissions were, because they were set out at starting at paragraph 35. And if one refers between the two parts of the judgment, the first three grounds of appeal put forward by the director were rejected in paragraphs 107, 108 and 109. The court indicated at 110 that it saw greater force in the fourth and fifth grounds of appeal, and one goes back to paragraphs 38 and 39, which are on page 104. The fifth ground is really consequential on the fourth ground. But the first answer I have to my lady's question is that the way that the appeal was presented by the director was, as indeed it had to be, as one involving a question of law. The director identified what he believed to be the question of law in paragraphs 38 and 39. If one then moves to paragraph 110, in which the High Court dealt with those grounds of appeal, it is right to say that at no point does the High Court say, well, the correct question for this court, paraphrasing paragraph 110, is not whether the decision reached by the district judge was one that was reasonably open to him, but whether it was at the end of the day wrong. The director submits that the High Court there was regarding the question of was the decision of the district judge wrong or not as a question of law. It was reformulating the director's questions of law.
I quite agree that the court would have assumed that it was a question of law, but we have to ask whether that was correct, because as I understand it, the Reby test wasn't suggested by the director. The Reby test came in somehow. I don't know whether it was in the course of the hearing or in the preparation of the judgment, but the conventional test was the basis of the appeal, i.e. what I would call Edwards and Bairstow, namely no reasonable tribunal could have reached this conclusion. That plainly is an error of law.
Yes.
No doubt about that at all. But then we find that Reby is brought in because that's that is, it were, is the bell rung when one thinks of proportionality. But there is no analysis, as I think you're accepting, of whether that is the application of Reby, not the formulation. Application of Reby is a question of law. And I feel that it might be, if there was a normative question, But at the end of the day, all this is coming down to saying there was an omission of a point.
My lady, yes. As I say, there is no particular paragraph in the judgment of the High Court to which I can refer that will help more expressly on that. When the High Court started, as it did at paragraph 111, to consider the reasons that the district judge had given for his decision based on an assessment of proportionality, the High Court did refer to, in more than one place, the district judge having erred. One can see at paragraph 114, the district judge's, the High Court indicates that the district judge's analysis was that indicated an erroneous approach. That was in respect of the discrete point about whether or not the actions of the appellants could properly be regarded as limited in duration. And I accept that the way it's set out there would be consonant with the approach in Edwards and Bairstow, that the district judge, based on the primary facts he found, either concluded that the period of time of the obstruction was limited in duration, or alternatively concluded that it didn't matter whether one looked at 5 or 10 minutes, the time between arrival and arrest, or one looked at 90 minutes, the time between arrival and release from the mechanisms. At paragraph 117, where the court has by then concluded its review of each of the reasons that were given by the district judge, the High Court indicates that the district judge did fall into error in a number of respects in his approach to the assessment of proportionality. When one reads back to the individual reasons that the High Court analysed, much of the criticism was that the district judge, in the opinion of the High Court, in making his assessment of proportionality, had considered factors that the High Court believed, or was of the opinion, were irrelevant. That harks back in many ways to the language of Wensbury, failing to take account of a matter that you should have taken account, or giving or taking account of something that you ought not to have taken into account. It's fortified when one looks at paragraph 117, because having criticised the district judge for those factors that he did take into account, which the High Court considered to be irrelevant, paragraph 117 in the director's submission indicates that there was an error of law in the sense that the district judge did not carry out the fair balance that the assessment of proportionality requires. And that, the director submits, would be a question of law. It may be said it's a question of law that is rather discrete to this case and differs from a situation where the district judge had made a proper assessment of proportionality, but in the view of the appellate court was wrong about it. Here, the divisional court is saying, the director would submit, that there's been a fundamental error in that the district judge has not, as it were, got past first base. He hasn't struck the fair balance between the rights, the convention rights of the appellants and the rights of others affected by the actions of the appellants. And
Well,
so
there's
it-
some,
Sorry,
there are some areas that will help you and some areas will not. So if re-B is not a question of law, then this point will only help you if it's good enough for Edwards and Bairstow.
yes. If it's good enough for Edwards and Bairstow, it helps me. It is indeed the director's submission. Let me make it plain, because the High Court did not in terms deal with it. One sometimes sees in judicial decisions a court saying that, or holding that it rejects an argument put forward by one party, but if it had even considered that argument, it would have rejected it in any event. Here, the appellant, the director, for the purposes of the hearing in the High Court, put forward a ground of appeal. The High Court allowed the appeal on the basis that the district judge had erred, had made a wrong decision in respect of proportionality. It did not go on to hold, for example, in a paragraph, that even if it had been wrong to apply the proportionality test, applying the test that the director had submitted ought to be applied, it would still have allowed the appeal because on conventional grounds, Wensbury, Edwards and Bairstow. The director, however, does submit that, although I can't point to any particular paragraph where the proposition is boldly stated, it must be the position, because an appeal on a question of law, only an appeal on a question of law, was permissible under section 111. And there's nothing to think that the High Court would have misread the ambit of section 111. Because the High Court allowed the appeal, it did determine, the director submits, that the decision of the district judge was wrong in law because his proportionality assessment was wrong in law, albeit the director maintains the submission that had the High Court not elected to apply the re-B test, but had dealt with the appeal on the basis on which the director put it forward, it is the director's submission that the outcome would have been the same, applying conventional criteria. The High Court would have allowed the appeal simply because, putting aside for one moment the assessment of proportionality, which 117 suggests the district judge did not carry out, when one looks at his positive reasons for the decision that he made, set out in paragraph 38 of the case stated, at no point is there any indication that the district judge took proper account, or indeed any account at all, of the right of others to have free passage. I pause for Lord Sales.
Thank you very much, Mr. McGuinness. Just on the question of re-B and question of law, I mean, obviously it wasn't for the district judge to apply re-B himself. The rule, as it seems to me, that he had to apply was summarising to assess whether the prosecution of the defendants was a proportionate action by agents of the state. So, as it seems to me, that was the legal rule that he had to apply. Up till now, I've understood the question which arises under re-B as to the test to be applied by an appellate court in looking to see whether the inferior court went wrong in its proportionality assessment. If it did go wrong, that would be an error of law, but a question arises as to the test for the appellate court to apply in that regard. Now, I wonder whether, in fact, an authority we ought to be looking at a little bit more closely is the Manchester chief of police case, because I think that was a straightforward judicial review case where the re-B approach was applied and actually discussed by Lord Culmouth at some length. And so, although I can see that re-B itself was a standard appeal on fact and law, when one's dealing with an appeal in the field of judicial review, I would have thought that what is an issue is an error of law. It's a jurisdiction which arises very much in the same way as where you have an appeal limited to a question of law. So if re-B was the relevant standard being applied by the appellate court in the Manchester case, am I going wrong here? That would seem to indicate that that is the appellate test in relation to a question of proportionality in assessing whether the inferior court has gone wrong in assessing proportionality.
Well, I would agree, because we can find perhaps we should just go to the Chief Constable of Greater Manchester case, which is starts at page 372 of the bundle. This was a judicial review. In fact, the decision had been made by I think the body that was responsible for issuing the certificates. There had then been an appeal by way of judicial review to the High Court, and from there onwards to this court, to the Supreme Court. And if we try to find the where Lord Carnworth deals with the appellate test, which I think is going to be at forgive me.
It's paragraph 53 onwards.
Thank you, Mr. Blackstone. Yes, proportionality in the appellate court is the heading. There was no, we can see there was no disagreement of the approach that was taken by the fact finder to make his own assessment of proportionality. We can see that there was a particular wrinkle to this in that the lower court had found that it had to look for a significant error of principle, which it was submitted by the claimant. I'm looking at paragraph 55, was too narrow and not supported by the reasoning of the Supreme Court. And at paragraph starting at paragraph 56, Lord Carnworth summarizes from the speeches from the judgments in re-B, and having carried out that review, agreed at paragraph 61 that he agreed with the submissions by counsel for the claimant that the Court of Appeal in this particular case had applied too narrow a test by asking simply whether the judge's reasoning disclosed a significant error of principle, and agreed that in fact the appropriate test was somewhat wider than that. We then have the section where Lord Carnworth reviews critically the paragraphs starting, I think, at paragraph 93 of the judgment of Lord Newburger. And concludes at paragraph 65, it was sufficient for the Court of Appeal to consider whether there was any such error or flaw in the judge's treatment of proportionality. And then we move on to the postscript. My submission would be is that the application of the Re-B test here, and indeed the application of the Re-B test in the Haringey Borough Council case, which was applied by the Court of Appeal in its appellate capacity to the findings of fact that were made in that case by the High Court, does indicate that Re-B, the test in Re-B, or the application in Re-B, is one of a question of law. I've put it as a matter of common sense as one of mixed fact and law, but in the submission of the director, mixed fact and law is sufficient. The court will recall that there was a discussion in the Edwards and Bairstow case as to whether or not the appeal in that case, where the commissioners had set out ostensibly primary facts and had then, as it were, reached a conclusion about the nature of the business transactions in that case, that the House of Lords, and I'm thinking in particular of the speech of Lord Simons, if I can just find bring up the report of the case.
While you're doing that, judicial review is not really comparable with a statutory jurisdiction, which permits appeal only on a point of law, because there are some circumstances in which in judicial review, the facts can give rise, an error in the facts can give rise to some form of remedy. That is not so in relation to appeal by way of case stated.
My lady, it is not, I accept, save in the particular case, the basis upon which this particular appeal was presented by the director.
Edwards and Bairstow.
Yes, based upon...
No reasonable tribunal could have reached that conclusion.
Yes.
But I think what you're saying, as I understood it, was your submission is that it's to be treated in the alternative as a conclusion that the Edwards and Bairstow test was satisfied. But
Yes.
that's not what we're discussing. We're discussing Re-B. And
Right,
I'm
yes.
just not clear where Re-B came into the picture. Did it come in during the hearing or later? I'm sure we should know, but it's told us. But when did it come up?
My recollection is that we may have been provided with the authority the evening before. Mr. Blackson and I were, Mr. Blackson was shaking his head. If Mr. Blackson thinks it was brought to our attention when we were, in fact, I think Mr. Blackson is right. I'm getting confused. There was an authority to which counsel was referred the night before, but my recollection is it was the case of Laporte, which the court cited in the course of its judgment.
Yes.
Mr. Blackson's position this morning was that the Re-B was referred to for the first time during the hearing.
Then he must be right about that. I was getting Re-B, I think, confused with the being provided overnight with Laporte.
So the court hadn't really got full submissions because there were no post-hearing submissions.
There were no post-hearing submissions, my lady, and Mr. Blackson makes the entirely accurate point, which in fact is confirmed in the judgment of the High Court itself, that the appeal had been presented by the director and responded to by the then respondents, now the appellants, as a conventional appeal on the Edwards and Bairstow, what I would still call mixed law and fact background.
Well, there the fact doesn't matter because it's the extreme situation that a tribunal has reached a conclusion which no reasonable tribunal could reach.
Yes.
That of itself constitutes a point of law, even though the process of reasoning was on the facts. That's really not a problem, but in terms of error of law.
Yes, my lady, other than having referred the court to the structure of the appeal in the High Court, that it was brought as an appeal on a question of law and must have been dealt with by the High Court as an appeal on a question of law. The High Court regarded the application of the Re-B test as one of, at the very least, mixed law and fact.
Yes, if they considered the point. It's not evident to me that they did consider the point, because your references to erred, the word erred, suggests that they were in fact thinking of the conventional test from time to time. And the passage that I've shown you at 100 is not about question of law.
My lady,
I think Lord Stephen would like to chip in at this point.
Yes.
The mixed fact and law, is it too simplistic to say that the legal aspect of that is the question as to which factors should or should not be taken into account? And so that leads you back to the points you make about the High Court saying that there were errors in the judgment of the district judge, taking into account factors which ought not to have been taken into account. Those would be legal points, in my view. But my question actually is aimed at how all this was articulated in the case stated. Because if you go to page 143, there is no suggestion by the director that the question of law was, for instance, the various factors that the Court of Appeal then found ought not to have been taken into account at page 119. It's just compendiously put forward, as it were, without actually analysing how it was alleged that the district judge took into account an irrelevant factor. It didn't, for instance, if you go to 119, say that paragraph 111 on page 119, it didn't say the district judge was wrong to take into account. The district judge was wrong in law by saying there was no form of disorder. So it didn't identify, unfortunately, the actual points of law, the specific points of law, which were the district judge had improperly taken into account.
My lord, yes, I accept that paragraph 41 of the case stated at page 143 of the bundle, which sets out the question for the High Court, is somewhat briefly worded. I accept that the first sentence, whether I was correct to have dismissed the case against the defendants in these circumstances, is not particularly illuminating. No doubt conscious of the fact that there had to be a point of law under section 111 of the Magistrates' Courts Act, the district judge then went on to say that the point of law that was involved, slightly repetitious, is whether as a matter of law I was entitled to reach the conclusions I did in these particular cases. All I can say, I suppose, in defence of whoever was responsible for that, whether this was the district judge's own formulation, or whether in fact he simply accepted
it's your request to state a case, and you have the ability, once the case stated is sent to the director, to actually make amendments, propose amendments to it, and none of that was done. So here we are in the Supreme Court trying to grapple with what is the point of law, when years ago, on the 26th of April 2018, no one defined it.
Lord, I accept that entirely.
I wonder, Mr. McGuinness, I mean, this particular question in a case stated is not that unusual. It's not ideal, but one comes across it quite often. The case you were making to the High Court is set out at paragraph 38 of the High Court's judgment.
Yes.
As I understand it, you were saying, quoting Edwards and Bairstow, that there were things in the stated case which ex facie were bad law. For example, you were saying that the district judge put on the wrong side of the balance certain factors which, on a proper analysis, should be on the other side.
Yes.
Or it was also taking account of things which were irrelevant.
Yes.
And then you said in the next paragraph, as a consequence of that, in any event, that they had come up with a result, again quoting Lord Radcliffe, which was a determination which contradicted the only true and reasonable conclusion. That essentially was the case you presented, as I understand it. And that case, I understand, was accepted by the High Court in paragraph 117.
Yes.
Yes. So basically, Edwards and Bairstow has two limbs: ex facie error of law on the stated case, and even if the error of law is not patent, then you can infer an error of law where the determination contradicts the true and only reasonable conclusion.
My lord, yes, and
you, the High Court found for you on both grounds. I'm not sure if Ray B adds very much to that, but as Lady Arden, I think, has been pressing to identify what's Ray B bringing to the picture.
yes.
Because I mean, if there is an error of law, then one doesn't have to say is the error of law one which no reasonable judge could have reached. If there's an error of law, if the law is wrong, then the
Yes.
test is that it's wrong.
My lord, yes. Yes, I accept all of that. The position that we were in was that, as I indicated a few minutes ago, the High Court elected not in terms to include a paragraph along the lines of that if Re B is not applicable, then applying conventional principles of law, this appeal is still allowed. And inevitably, when the questions for this court were posed, drafted up by the now appellants and amended by the court, the alternative position, it doesn't emerge in the questions for this court, although it is tolerably clear, the director submits, from reading the judgment as a whole, that the same outcome, there would have been the same outcome had the High Court not gone down the Re B route.
Yes.
And I don't really think that there's very much more I can say. We've between us, I think, analysed most of the paragraphs of the case stated. Perhaps we're not there yet. My lord.
I mean, from paragraph 110, it's clear, isn't it, that the court did not apply Edwards and Bairstow, it applied Re B. It said it's asking the question for the court is whether the decision was wrong, not whether it was conclusion was one that was not recently open to the district judge. That's the question they're addressing and answering.
My lord, that is right. That it may be that because if one starts with how does an appellate court forensically decide that the assessment of proportionality made by the trial judge was wrong, it's difficult to see of any other common sense approach other than looking at the reasoning process of the judge below, analysing what influenced the judge in reaching his or her decision below, and then looking to see whether there were any other matters of significance apparent from the primary facts that have been found, which the judge below did not address. In other words, forensically, there may not be much difference between reaching a conclusion on conventional grounds that there was an error of law applying the Edward and Bairstow principles, or coming to the conclusion, applying the Re-B test, that the assessment of proportionality was wrong. One ends up at the end of the day looking at exactly the same matters that are included, the same matters that are excluded, and looking at the reasoning process of the judge whose decision is being appealed. That may to some extent explain why, whilst I accept my Lord Hamblin's point that paragraph 110, which prefaces the actual substantive reasoning of the High Court, prefaces it by, particularly by virtue of putting the word wrong in inverted commas, that the court is now going to move on to apply Re-B to the district judge's reasoning, why inevitably, when it deals with the details of that reasoning, it uses language redolent of the more conventional approach. Because although the test may be differently expressed, what you're looking for, what the appellate court is looking for, is in essence not that very much different, the director would submit.
Yes, I mean there is I think a match between your submissions and what is said in the two heads in paragraph 117, which I think Mr. Blackland accepted, was a finding first of all of error of law, and secondly the application, which may or not be right, of Re-B to the overall result. So on the one hand, there is what you would I think present as an error of law, either the consideration of irrelevant the taking into account of irrelevant considerations, or putting them on clearly on the wrong side of the balance. That seems to be your section 30, your paragraph 38 criticism.
Yes.
That's the first head, and then further, and in any event, there's an application of Re-B to the result.
Yes.
Yeah, but there are two separate heads of decision.
My Lord, yes. I accept that is how paragraph 117 reads, and
well, in any event,
perhaps to a slightly lesser extent, paragraph 129.
It's like it muddies the water.
Yes, yes. Well, certainly paragraph 129 doesn't have the same clear reference to the Re-B part that is in paragraph 117. And indeed, what Roman numerals 1 and 2 do seem to hark back to the submissions made by the director set out at paragraphs 38 and 39 of the case stated.
I said it muddied the waters really because the first sentence says that the assessment was in all the circumstances wrong, and then the learned judge goes on to say the taking account of irrelevant considerations. Now that clearly is a straightforward error of law if he's right about that. And then there's the overall conclusion point.
Yes.
But if you take the two paragraphs together, there seem to be two grounds. One is ex facie error of law, and the other is the outcome is the balance is wrong.
Yes.
Yeah.
Could I just ask whether it's really right to say it doesn't matter which it is? And I appreciate for the purposes of saying, well, the result is the same. But for the purposes of the administration of justice, it does make a difference which is the right test. It's very important that this court should make it clear.
My lady, I agree entirely. And this court will have the opportunity, indeed, in order to answer the questions that have been posed by the High Court, it will have to perhaps apply the clarity to the approach that the High Court clearly endeavoured to follow, but perhaps not. And again, insofar as blame must be ascribed, Mr. Blaxland and I, having been met with a reference to, or at least being invited to address the court in respect of Re B, were not sufficiently suitably armed to make as clear submissions as to whether or not, for example, I might have submitted that it wouldn't in fact have made any difference to the outcome. And because I hadn't been armed to argue Re B, unless the High Court thought there was something additional to be gained by a consideration of Re B, could I please have my appeal decided on the conventional grounds that I had put forward? But I agree entirely with my Lady Arden that this court will have to answer that which is perhaps a little unclear at the moment.
And while it may on your submission make no difference in this case, there are other cases in which the adoption of the Re B test would have a profound influence, because it invites the court to take a much more hands-on view about proportionality. My lady, yes, I accept that. And indeed, in the context of criminal law, there's no getting around it. It would be a radical shift. Thank you. My lords, my lady, I've got about 10 minutes left. Can I return briefly then to the other question, which I foreshadowed by my submissions as to what facts were apparent from the case stated, what facts were implicit or could be inferred from the case stated, and the correct analysis in respect of other facts that is apparent from the case stated. The court, I think, has my submissions. Mr. Blaxland, to some extent, has done the job for me by referring the court to the authorities on which I would have relied, and I've referred the court to the one additional authority of G against Germany. Just dealing with some of the particular criticisms that the appellants make. They say that the appellants argue that the High Court did not give any sufficient consideration to the manner, form, and location of the appellants' activities. Insofar as that is relevant, it did not feature in the reasoning of the district judge. There's no particular finding of fact in the case stated in relation to it. It has to be approached against the background that the arms fair had not commenced. So this couldn't be a case of the appellants wishing symbolically in front of the people against whose conduct they were complaining, doing something in the sight and sound of those people. And with particular regard to the form of protest that was adopted here, unlike, for example, in the Tabernacle case, where there was a particular symbolic importance to the Aldermaston Women's Camp that was the form of protest in that case, there is, the director submits, absolutely nothing here that indicates or suggests that there was a particular symbolic significance in the appellants lying down on the carriageway of the road that led to the Excel Centre with their arms locked together in circumstances where the reality is, insofar as they were seeking to get a message across, the police, it is clear, were present because they'd been dealing with the other, perhaps more conventional form of protest of walking along the carriageway rather slowly with the traffic behind going to the Excel Centre.
again, it can be inferred as a matter of common sense that perhaps why there is not any or very much evidence of vehicles actually being obstructed was because is it not likely that the police who were present would have taken prompt steps to ensure that traffic that otherwise would have used this particular road to the XL centre was diverted? Because one can only imagine the potential risk if cars were driving along that road on the correct side of the road, and then suddenly to encounter these the obstructions of the appellants lying in the middle of the road. The particular complaints that are made, one complaint that is made by the appellants is the nature of the road. This was, it is said, but a mere slip road. The director points out that this road was chosen. Whether or not it was a slip road, this was a planned exercise, and there must have been, as a matter of common sense, a particular reason for choosing this slip road. If the appellants were seeking to draw attention to their viewpoint, to which of course they were perfectly entitled to do, it may have made less sense to try and draw attention to a road which wasn't likely to be used. Alternative routes, the point is made that there were alternative routes that the traffic could have taken. The logic of my submission but a moment ago is it's highly likely that the traffic was directed down alternative routes by the police. This point, the alternative routes point, which is referred to in some of the Strasbourg authorities, I accept, would have been of far greater significance had the police been on notice that the appellants were intending to conduct their protest in this particular way. To criticise the police, or to criticise the authorities because there were alternative routes is, the director would submit, not a fair criticism, bearing in mind that the police were there dealing with protesters who were already there. The director's made the point in its printed case, it's a matter for the court what view it takes. But the police that morning were faced with protesters walking slowly along the road towards the XL centre, with protesters, these appellants, lying in the middle of this carriageway. And as the court can see from the case stated and from the judgment of the High Court, shortly after these appellants were eventually removed, in the case of Cooper and others, on another road, a different form of obstruction was adopted. And it's against that background that one ought to look at whether or not there's any real criticism in the conduct of the police, and whether in fact this is a case, as the appellants submit, that the authorities did not show appropriate tolerance. And in fairness to the district judge, whose judgment has been subject, certainly as far as the director is concerned, to some criticism in this appeal, it is fair to say that the judge did not reach his decision by considering, as part of the assessment of proportionality that he had to make, that this was a case where there had been a lack of tolerance shown by the authorities. My lords, my lady, that's as much as I wanted to say on question 1, in addition to my submissions before lunch.
I don't detect any appetite for further questions, Mr. McGuinness, so thank you very much. We'll pass back to Mr. Blaxland.
Yes, my lord, thank you. Can I come to what I submit as the heart of this issue, which has been ventilated in discussion both this morning and this afternoon? And it's the question of what was, if any, the error of law in this case. Because the court has proceeded on the basis that the the High Court identified the way in which the lower court had conducted its analysis failed to take into account relevant considerations or took into account irrelevant considerations. But if one strips it back and looks at exactly what it is that the was decided, it comes, in my respectful submission, down to this: that there was, according to the High Court, a failure to accord proper significance to the fact that the road was completely blocked for a significant time. That's what it comes down to in my submission. The question, therefore, is whether or not that evaluation amounted to an error of law. In our submission, it doesn't. What effectively it amounted to was a disagreement with an assessment of the factual issue, which is a different point. And I say that for this reason, that the district judge undoubtedly took into account the fact that the road was blocked and for how long. It was central in many ways to his judgment, or it's certainly a fact which he took into account. His conclusion was that that was not sufficient to justify an interference with the appellant's rights. The question, therefore, is whether or not there is a proper basis for a conclusion that that opinion, and it was an opinion, was not open to him. And in our submission, it was an opinion which was manifestly open to him to take. Not everybody may agree with it, but that's not the point. The question is whether or not, weighing the respective considerations, he failed to he failed to give sufficient attention to it, or failed to accord it sufficient weight. And that brings me to really the problem as it developed in this this appeal to the divisional court. The respondent's principal ground of appeal in the lower court was that the district judge had been wrong in principle to take into account convention rights, because there was a primary right to pass and repass along the highway. That was the first ground of appeal, and that was the principal ground of appeal. And then the two grounds of appeal which followed on from that developed it to this extent that there were irrelevant considerations taken into account. Grounds of appeal 4 and 5, which the High Court found had merit, were effectively supplementary grounds. So the irrationality ground, which was ground 5, and the failure to take into account relevant considerations and so on, which was ground 4, effectively developed the original grounds of appeal. And what happened, of course, at the appeal was that the court robustly rejected the first of the 3 grounds of appeal on a principal basis, but then considered the remaining 2 grounds of appeal effectively as freestanding grounds. And in our submission, the problem with that approach is that what then happened was that the court was reformulating those grounds of appeal by reference to a different test, a proportionality test, and that, in a sense, is where they went wrong in our respectful submission. But the bottom line here is that on proper analysis, that there wasn't, in fact, an error of law at all in the way in which the district judge approached the matter. That's our principal submission. My further submissions are really subsidiary to that, because that is the principal point. But can I just deal for a moment with the issue which was raised by Lord Sales this morning, which I said that we'd give further consideration to, and that's the question of whether or not, if the court were right we are wrong that there was an error of law in the way in which the district judge approached his approached the facts of the case, or his assessment of the facts of the case, whether or not the district judge was then entitled to conduct his own proportionality exercise, which is what he did here, or whether or not he should have remitted the case to the lower court. That's the question. Our submission, having considered it further, is this: is that even though it is correct to say that there was essentially no significant issue on the facts of the case, nonetheless, it's our submission that the case should have been remitted, because the exercise to conduct a proportionality exercise depends upon an overall assessment of the facts of the case, including, and this is absolutely vitally important, a consideration of the evidence of the defendants. It's not correct to say that the defendants in this case just gave evidence about why they were doing what they were doing. That was obviously an important part of it. But they gave evidence about the context in which they were acting and the extent to which they appreciated that there would be disruption. As one of them said, it didn't amount to very much disruption, did it? And they anticipated that. Although they intended to cause some disruption, there's no doubt about that. On the other hand, they were able and did give evidence about the broader picture. So it's our submission that the appropriate course would have been for the court to remit it. And if I can just really adopt as a way of looking at it, the way in which Mr. McGuinness has approached it, which is that this is a question of mixed fact and law. If it is a question of mixed fact and law, then there is no question in our submission that it should be remitted to the lower court for a redetermination. And likewise, if this court were to conclude that there was an error in the way in which the lower court, the divisional court, approached it, it's our submission that that should effectively bring the appeal to an end. The appeal should be allowed, and it wouldn't be appropriate in those circumstances for this court to engage on its own proportionality exercise for exactly the same reason. It's a matter which really felt to be considered by the lower court. Can I just very briefly, and I will be brief, address certain matters which were raised this morning on the facts of the case, because my Lord Stevens explored with my learned friend Mr. McGuinness the question of the evidence as to whether or not there was any disruption here. The fact of the matter is that although it is correct that the appellants themselves did intend to cause some disruption, they made no bones about it. It was, in fact, it was critical to the effectiveness of their protests that there would have been a degree of disruption for the purpose of publicising their cause. Nonetheless, there was ultimately no evidence, either directly or by inference, that there was any disruption to traffic. There was speculation that traffic may have been diverted, disrupted, obstructed, but it was no more than speculation. There certainly wasn't material upon which a proper inference to the criminal standard could be drawn. Can I very briefly make mention of the case of G, which is the German case, the anti-nuclear arms protesters, case referred to by Lord Neuberger in the case of Samedi and referred to in Lucas. It's important to note that in that case, it was an appeal against a conviction for a specific criminal code offence of coercion. That was the crime which was being considered. And so, albeit superficially, there was some factual similarity between that case and the facts of this case. It's our submission that as with all of these examples, one needs to approach factual comparisons with a great deal of caution and look at the overall principles. And the overall principles are expressed very clearly in the case of Kudravisius. And it's my submission that that should really be the basis upon which the court approaches these appeals. Would my lord just give me one moment, because I have Mr. Greenhall with me, and I just would like to have just a few words with him.
Of course. Do you want a short adjournment, or do you want just to? You can just switch your microphone off while you speak to me, if you so wish.
Yes, certainly. It's probably easier if I just switched off, and I shall turn my back, I'm afraid, on.
Thank you.
My lords, I'm very grateful. There is one issue which I hadn't appreciated, but Mr. Greenhall, who is involved in a much earlier stage than me, has pointed this out, and I do need, I think, to draw it to the court's attention, that in fact the case of Re B was referred to in the appellants, or responses then were, skeleton argument, but in a different context. What hadn't been appreciated was that the proportionality exercise would apply to this appeal as opposed to a Wednesbury test. But as a matter of fact, and he's quite right to point this out to me, that authority did find its way into the skeleton argument for the respondents. It doesn't alter the point, as a matter of fact, that both myself and Mr. McGuinness approached this on the basis that we were talking about a Wednesbury point. And the other just factual point, if I might, is this: that my learned friend relied upon the intention of the protesters to disrupt, about which there is absolutely no doubt, an intention which was effectively based upon the fact that they were seeking to get publicity for their cause, and this was a way of doing it. But whatever their intention may be, it remains the case that the location they chose at the end of the day meant that there appears to have been, or there's certainly no evidence that there was any traffic or that was in fact disrupted, as a matter of fact, and that had probably a lot to do with the fact that this was just an access road to the Excel Centre. It's not a sort of major thoroughfare or anything of that sort. But just those points, my lord. That's those by way of addition.
Mr. Blaxland, thank you very much. I don't see any further questions being raised. So it really remains for me to say that the court is very grateful to Mr. Blaxland and to Mr. McGuinness for their clear oral submissions and their written cases. And also we are very grateful to those who have assisted in the preparation and presentation of this appeal. The question of the appropriate scope of appellate review is an important one, and the court will take time to consider the matter and will give its judgment in due course. Thank you very much. The court will now adjourn.